Good luck to you, sir. You can go back with the bailiff.
Okay.
Yes, sir.
I think Mr. Parker might be really good.
Haha, you're funny.
I'm getting there. Let's
I'm in
see.
no hurry, Judge. I'm not like robust.
I didn't say earlier.
I probably don't want to know what you guys are saying. Herbert Kane, 24 DCCR 1083.
We were in county court 2 the other day, and it took literally 20 minutes for somebody to do it. Literally 20 minutes. And I was doing rejection. He tried to say, I believe it. I'm gonna get on Zoom and beat you. So I approached the judge after that plea. I said, by the way, Judge, Mr. Ross is on Zoom. He called his office to get on Zoom.
That's funny.
And he had to wait another hour.
All right, sir. Are you Herbert Kane? Is your name Herbert Kane?
Yes, ma'am.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment with the offense of assault on a peace officer, and that is from April 3rd of 2024. And what that means is if you go to trial and a jury finds you guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand what could happen if you go to trial and you're found guilty?
I understand, but can I ask you a question?
Sure.
If I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing, what happened surrounding this offense or what they've charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide 2 things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get a.
Here's the thing. Well, here's the thing. The offers, I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
And Your Honor, I've discussed these facts that concerns he's had with Mr. Nichols and explained to him the situation after he's had evaluated. I've again talked to about the offer, and Mr. Nichols has remained steadfast on the offer that he's made previously, which is the offer today.
Okay.
Judge, just so that you're aware, it's not his first offense. He was actually before you in 2018.
Okay.
So they think for
Burglary of a building, it sounds like.
the state jail felony was
Mm-hmm.
it was dismissed.
I've gone over it.
Okay. So it doesn't appear that it was dismissed, but I just want to make sure now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case as far as what she said.
Look, regardless of that, that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay. That can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Mind if I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what,
It was sorry.
Go ahead.
It was a felony conviction with county jail time, so he may misunderstand that he is already a convicted felon.
okay. So it sounds like you got a 1244, which means you got a state jail felony conviction but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks like.
So I got 1244A.
Mhm.
Okay, but from what I understood, it got dismissed.
It doesn't get, it did not get dismissed.
So 1244A is not reduced.
It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you.
That's what I'm saying.
It's a state jail felony conviction, but we're going to stop talking about that because it doesn't matter right now.
I was attempting to find out because I ended up going to Judge Clint Woods for like.
That's misdemeanor court.
Exactly, for the reduction of.
Listen, it doesn't matter. Whatever that prior is or is not, does not matter on this case right now. This case that you're charged with, second-degree felony, assault on a peace officer. The district attorney's office has made an offer of 5 years. Take it or go to trial. The prior is not what is enhancing you. It's not changing this. The offer is what the offer is. Do you want it or do you want to let a jury decide?
How much back time?
Well,
How much time I actually have to do?
I've discussed that with him this morning, Judge.
Okay.
He has approximately 100 days.
So
credit
hang
for
on a
time in
second.
jail.
You're asking me questions that your attorney has already gone over. Listen,
I didn't get
don't
it
talk
that
over,
day. I was attempting
don't
to-
talk over me.
for school, so
Listen.
I was trying to figure out-
Listen and don't talk for a minute because I don't think you've been listening to Mr. Parker. Mr. Parker sounds like has explained everything to you. He's asked the clerk. She has figured out your time, how much credit you have. I don't know how much time. He doesn't know how much time you would actually do on a 5-year sentence because it depends on parole and good time and all of that and how you behave in prison. It's a 5-year sentence. You would be eligible for parole after a quarter of it. That's all we can tell you. And he can tell you how much credit you have. But it's just eligibility for parole. We don't know when you're really going to make it. If you do, that's up to you and how you behave. I need to know if you want to take that or if you want to go to trial. So what do you want to do?
So can I ask you another question?
Sure.
So you said a quarter of it I'll be eligible for parole.
Mm-hmm.
But he said I have 100, you know what I'm saying, 100 days.
Yeah.
Back time. So
Okay.
I already did, what, like 6 months now, and I got 100 days back time.
So here's the thing. I went to law school because I'm not good at math. I have no idea. Well, do the math. I don't know. I mean, it's a quarter of 5 is
About a year and
3/4.
about a year and 3 months.
So you know,
I was trying to make sure. That's
Well,
all I was trying to say.
we're not here for a math test. Do you want to take the deal or do you not want to take the deal?
He asked me today, Judge, if he would get out if he took the deal. I said you would not get out
No,
today. And
you don't get out today. You got to go get your number and do all the stuff. Mr. Parker's answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial and this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do?
You can take it to trial.
Okay. So we'll put your case, you understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right?
How could it not get better?
Because I'm telling you, it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today because I don't play with my trial docket and just put cases on it. So somebody thinks, well, if I make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand? And I'm not doing this to just for everybody on the trial docket. If you want a jury to decide, fine. You want the 5 years, take it today because after today, 5 years is gone. What you want to do?
Let's see. So you pretty much told me in so many words that you weren't going to allow me to beat my case.
No, I'm completely going to allow you to beat your case. If you want to take it to a jury, 100%, we're going to get it set for trial and you'll be up for trial in whenever the next available trial docket is, and a jury can decide if you're guilty or not. And if you're guilty, then they can sentence you to whatever they think is appropriate. So absolutely, I'm telling you that you can try to beat your case. I just want you to understand that if you think you're putting it on the trial docket to buy some time to get a better deal, and then you want to plead guilty later, that's not going to happen.
I'm saying that's, if anything, he used excessive force, and it's not necessary. So
Well-
not to be retaliation for public service.
We're not negotiating. Mr. Kane, we're not negotiating. You and I aren't negotiating today. The negotiation's done. Do you want the 5 years or do you want a trial?
You say the trial will be within like a year?
I have no idea when it'll be. It'll be the initial, I mean, it just goes on the trial docket with everything else. And as soon as it comes up, if it's number one that day, it goes. It depends on how old the cases are. It depends if somebody's in custody. It depends what type of case it is. So I can't guarantee you when your trial will be. I would like to think it would be, but no, a year or less, but I can't for sure tell you that. We're doing really good with moving trials, do the best we can, but I can't tell you for sure when that would be.
Question, but one more question, and I'll let you know. On that burglary on a.
We're not going back to that. Just let me know. We're not, no,
That's what's that change on the door.
we're not going back to a burglary.
Witness here,
Okay. Do you want the deal on this one or do you want to go to trial?
huh?
Do you want the deal on this one or do you want to go to trial? We're not talking about the other case again.
What's it to do?
All right. I'll hold it while y'all go. You need to do the paperwork with Mr. Parker this morning and then I'll take care of it in a few minutes.
Can I plead not guilty?
No, if you're not, no. If you plead not guilty, then you go to trial. You're either going to say you did it or you didn't do it.
Oh, I didn't do it.
If you didn't do it, then we're going to set your case for trial. So we're going to put your case on the trial docket. And so, Mr. Kane, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. If with your permission, I can release him and I can appoint another attorney today who can start getting ready for trial a little quicker. Is that okay with you?
After Mr. Biller,
You're going to get who I give you.
that's on that case.
You're going to get whoever is on next up on the list. So it's probably not going to be him. Okay. He's not on our list anymore. Yeah. All right. So do you want to keep Mr. Parker or can I give you another attorney?
Okay, nothing.
Okay. Mr. Parker's released. We'll give you another attorney. You can go back with the bailiff.
So what you just witnessed was a real courtroom exchange between a judge and Herbert Kane, a defendant facing a second-degree felony charge of assault on a peace officer stemming from an incident on April 3, 2024. With a punishment range of 2 to 20 years in prison, the stakes in that courtroom were anything but small. The state extended an offer of 5 years, and from the moment that offer hit the table, this hearing became a tense back and forth that revealed just how high the pressure runs when a defendant is forced to make a life-altering decision in real time. Kane pushed back. He questioned the charge, tried to revisit a prior burglary of a building conviction from Jefferson County that he believed had been dismissed, and repeatedly attempted to negotiate from the defendant's chair. But the judge was clear. The prior conviction stood. It was a state jail felony served under a 12.44 agreement in county jail, and more importantly, it had no bearing on the current offer. The 5 years was the 5 years. The judge made it unmistakably plain. Take the deal today or go to trial. Because once this case hits the trial docket, that offer disappears, and the number only goes up, not down. After all the questions, all the back and forth, Kane ultimately rejected the plea. He maintained his innocence, declared he didn't do it, and chose to take his chances with a jury. The judge released his court-appointed attorney, Mr. Parker, and moved to assign new counsel to begin preparing for trial. This is the reality of the criminal justice system. Decisions carry weight, offers expire, and once you choose your path, you walk it. Whether Kane made the right call, only time and 12 jurors will tell. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.